Jenine Hulsmann, Emily Chissell, Anush Ganesh, welcome to Digital Markets Research Hub. We have agreed today to debrief an AI summit organized for the second year in a row by TL4, and it's a great opportunity for us to address the key topics which have been covered comprehensively. Anush and myself had a great opportunity to participate in this event. It was fully packed by really insightful ideas. And Janine, you have been chairing it for the second year in a row. And thus you have this kind of helicopter view about the mapping out the event, the key topics, the key problems, the evolution of the problems from 2024 to 2025 and onwards. So maybe let's start the first round by just looking at the event itself, outlining the key ideas and messages which have been articulated there. Janine, let's start with you perhaps.
I guess in terms of the background to the event, first of all, we started the event 2 years ago because it was really apparent that regulators and competition agencies were really starting to discuss this topic. And even more importantly, they were looking to start acting. And they were looking to start acting at a point where the technology was still sort of very much in its infancy. I think largely, and at the conference, I think Emily made this point very clearly. But there was a concern that they felt that in relation to some of the Web 2.0 technologies, that they had missed the boat. And so they felt this time around that they needed to start sort of intervening very early in the development of the technology. And as I guess as a practitioner in private practice, what was sort of really apparent to me was that a lot of the debate wasn't really being driven by people with, or wasn't really being driven by a high level of knowledge or a high level of understanding of where the technology was going to go and what the different competition issues, might be in relation to AI. And so we were actually, particularly for the first conference, less so for the second one, we were actually quite worried whether we would have enough interesting sessions to fill an entire day with all the different sort of aspects of AI. But we were really pleased that we did. There were just so many different issues that come up as a result of AI, and so many of them have sort of different competition aspects. So one of the first areas that has been sort of looked at in detail is in particular all of the different partnerships that have arisen in the AI space, and that's something that I've spent a lot of time sort of working on. So that was one topic that we sort of dealt with. But then there's also been a sort of a lot of debate around the different sort of consumer aspects. So sort of safety, AI washing, then also sort of issues such as how do you go about regulating AI? Because the regulatory frameworks that were designed for digital technologies were all designed in advance of AI really becoming as big as sort of an issue from a competition perspective. And then finally, we get into sort of topics like sort of collusion and how will AI sort of either affect the ability of companies to collude? Will it change the way collusion occurs? And also, are there any sort of lacunas in the law that are perhaps not because the law around collusion was obviously designed well in advance again of most of the generative AI systems that we've got. So those were the types of topics that we discuss, and again, it was I think a very successful conference because we managed to find a large number of very expert sort of speakers who were able to come and not only discuss but just to a large extent sort of debate, educate. I think we had sort of really good sort of audience participation as well. Lots of interesting discussion around the lunch breaks and in the networking breaks. So that was the genesis, the background of the conference, what we were trying to sort of achieve. And I feel like we've sort of definitely achieved that, and it was really great, I guess, to be able to build this year on the it was the second conference, so we were able to really sort of take stock of what we said last year and sort of see if a lot of the issues that we had identified last year had really come to be sort of issues that the practitioner community was talking about. And I think in large part, we sort of, we had been successful in identifying issues, which was great as well. And we'll have to see next year whether we were successful in sort of seeing, where the technology and the issues may go in the year ahead.
Absolutely. Thank you very much, Jenine. It was really informative for us as participants, and I think it was really very well managed and insightful. Emily.
Yeah, no, I was just going to say, I think it would almost be remiss not to have and give a kind of conference that just focuses on AI and the issues arising from that, because it essentially, the frontier of the new technology that will affect so many markets and how businesses and consumers operate in so many ways. It's a game changer. And so having a focused conference that really kind of digs into that, and with people that really do understand both the kind of legal and economic. And I think in future it'd be really interesting to have some technologists in there as well to really give an even deeper understanding of the technology to support that discussion. But I think it's fundamental because it will just affect so many things. But we're somewhat kind of in the dangerous place of having to kind of talk about it whilst it's still so evolving that it's going to be quite interesting for us to see how some of our predictions and some of our thoughts and concerns or not concerns about how these markets might develop actually pan out in the future. So we'll see that play out live.
Exactly. Thank you very much, Emily. Anush.
Thank you very much.
And by the way, you have published a conference debrief, Anush, and I think it would be very helpful to colleagues to look at the summary of the key messages in the reading format. Now we have audio-visual format of this and deeper conversation.
Yeah.
Thank you for flagging that, Ulis. So from an academic perspective, as well as the SKIDA project's perspective, so SKIDA project is a Shaping Competition in the Digital Age project, which Ulis and I work on along with some other colleagues. So we try to look at digital markets, and AI is somewhat our main focus right now. So this conference was absolutely brilliant for us from an academic point of view. The summit addressed a critical moment as well, because we're seeing the first year of the DMCC implementation coincide with rapid developments in AI and foundation models. And it was outstanding to see the variety of speakers, because as Jenine and Emily, you mentioned, there were people from legal backgrounds, from economics backgrounds, also technology backgrounds, because the keynote speaker was Dr. Karen Croxton, who's the Chief Data Officer of the CMA. So the variety was great. And also, I think we had a few people representing AI firms as well. I think Lucio, one of the AI firms, was one of the reps as well at the conference. But from our perspective, the breadth of the issues was first of all remarkable to see. Also to see the CMA's strategic vision through to this, considering these granular challenges of algorithmic collusion and copyright in AI training, which also became a significant aspect that was discussed in one of the panels. So some of these themes were seen regularly throughout the conference, and there was a sense that regulators are also leaning in on real-time learning. So they're seeing what the things as they happen, and then they're trying to act. So this was also somewhat remarked in Dr. Karen Croxton's opening keynote, as well as Breeze Alibert's European perspective keynote. So some of these discussions were followed on AI partnerships, SMS designations, as I said, the copyright data nexus, which circled back to the central tension. How do you regulate markets that are evolving faster than traditional regulatory timescales allow? So we at SKIDA are also looking forward to explore some of the exploring some of these issues more from an academic point of view. But going forward, I think the nature of this conference brings one thing to light, that many of these different facets, academia, practice, but different parts of practice as well. As you mentioned, Emily, technology specialists, legal specialists, economists, they all need to come together. We all need to come together to see what's the way forward for perhaps an optimal way forward.
Thank you very much to all three of you for introducing to us the key topics of the event. I propose to address one which is kind of one of the central institutional issue, namely the CMA strategy for the following 3 year 26-29 through the lens of the rapid evolution of AI and being mindful how decisively important the position of the CMA in nurturing or shaping or observing or monitoring these markets is. What do you read between the lines of the strategy and from the strategy itself, looking at it through the perspective of your knowledge and your communication with the CMA enforcers and officials? Jenine.
So I think one of the really key things that the CMA did, which I think was incredibly powerful, was that they put together a variety of very good overview studies to their foundation model market study that really, I think, sort of set out the landscape, both in terms of how the technology was developing, but also in terms of what the different commercial arrangements were that were being put in place to try and sort of develop the technology. And I think in doing that, the CMA has, I think, sort of really put itself at the center of the debate around AI, and also sort of created an incredibly sort of strong sort of knowledge base within the CMA. So I think, I think it's really important before we get sort of looking forward is just to sort of pause and remember what the CMA, I think, has done that has been sort of, I think, very, very influential. And the second thing I think that the CMA has done that's been very influential has, and that's why it's been so great to have Karen come now twice to the conference, is that they created this role of the Chief Technology Officer and really sort of embedded technologists within the CMA. And I think, Emily was absolutely right. You can't have this debate unless you understand more about the technology and what is and is not sort of possible technologically. Where are the sort of the specific issues that are sort of arising as the technology itself, as we said, is developing so incredibly sort of quickly. So I think those two sort of facets in and of itself have been sort of incredibly important in the CMA sort of setting itself up at the forefront. I think of thinking around this area. And I guess one other thing that's been very interesting is to watch the European Commission also now start to talk about doing something sort of very similar, having a chief technology officer, also sort of starting to think about, again, not just taking enforcement action, but taking action really to try and make sure that there is a good sort of knowledge base that underpins everything they do in this area. Then if we start sort of thinking, ahead as to how the CMA, I think, is going to try and sort of look at this area, if we, I guess one sort of particularly interesting area is around sort of merger control. This was an area, again, where the CMA sort of got in early, tried to make sure it had a sort of a very clear understanding of how AI partnerships are sort of operating. I think what we may well see sort of going forward is the CMA taking or being able to take a slightly sort of more light touch approach to some of the mergers, because they have done a lot of the thinking sort of upfront and sort of understand the issues. Now that, I think it's going to be sort of very interesting. We've got sort of a very large number of, still a very large number of partnerships coming down the track. So we'll have to sort of see how the CMA's sort of merger control or new merger control approach is applied in this area. But But this is going to be sort of, for me, one of the really interesting areas to see how the CMA sort of builds on that knowledge base, builds on, I think, the understanding now that AI is not necessarily going to follow exactly in the footsteps of the Web 2.0 technologies. There are some very significant differences between AI and what we've seen in areas like search that I think will sort of influence their thinking. But that's one aspect, and I'm sure the other panelists will talk about some of the other aspects of the strategy as we go forward.
Can I have a quick follow-up question
Yeah.
to your contribution? You have highlighted your observation about the normative choice of probably being a little bit lighter than recently towards mergers, potential mergers in the industry. So kind of normative position is understandable. Normative shift is quite predictable. But we hear people who agree with this because it's terra incognita, and people who disagree with this saying that, well, the CMA generates knowledge, becomes kind of top tier expert in the area, maybe it's time to apply it in practice. Okay, this is normative polarities. But in terms of, from your experience, how much it can potentially do, even if there is a normative desire or ambition to kind of to micromanage this industry? Is it a side dish, or we can do a lot if you do this strategically?
I think it's really hard. I mean, I think what's sort of really interesting now, if we start to think about how some of the partnerships are actually happening in practice, one of the sort of the key areas that where people are sort of really trying to think about some sort of capabilities is just in terms of people. So it's hiring teams. So actually, a lot of the recent agreements that we are seeing, a very interesting one is the NVIDIA hiring of a number of people from Grok AI. Grok was creating a sort of a competitor to the NVIDIA GPUs, and one of the individuals that they've hired was actually sort of very instrumental in designing the Google TPUs, which is also another competitor to the silicon that NVIDIA produces. Now, when you're looking to hire a group of people, and that group of people are largely located outside of the UK, it does create a sort of an awful lot of very important sort of issues. Can you stop people in another country working or deciding to switch their employer from one to another? Can you actually sort of implement interim enforcement orders? And it's been really interesting to see in all of the recent cases, interim enforcement orders have not been used. And what sort of conflict of law issues sort of arise, and who should really take the lead in these sorts of cases? All of these issues, I think, sort of really come to the fore. And it's also sort of super interesting to sort of see, particularly the way the industry is developing. People are moving from one developer to another, but then again, sort of branching out and setting up. We've had a number of people leave OpenAI, for example, and set up their own sort of companies that have all got sort of very significant valuations now. So I think this is just one of those. It's a very difficult industry to talk to, and a very difficult point in the development of the technology to really sort of try and intervene. So I think there really are a number of sort of practical issues here, legal issues, and then it gets into the question of do we want to intervene in where individuals decide to sort of work, which is a sort of another issue. So it creates quite a sort of an important sort of theoretical policy sort of issue for us as well. I think in terms of, merger control, we're not seeing a lot of the traditional acquisitions, which I find sort of really interesting as well. Instead, what we're sort of seeing is a lot of joint ventures, which are, again, sort of not unusual when you start thinking about the development of new technology, where you're trying to bring together a variety of different sort of capabilities in order to push the frontier of a particular technology forward. That's typically the sort of the type of area where joint ventures are welcomed. So again, to sort of step in and say we won't allow joint ventures in this particular area, or we will impose very harsh sort of conditions on it, or we won't allow joint ventures with any of the big tech firms. And these are the firms that have a lot of the compute that is required, I think would be incredibly sort of harsh. And I think finally, if you look at it from the perspective of many of the people that are starting up these companies, until recently, many of them, OpenAI didn't have any revenue, for example. It didn't have much in order to trade for the compute that it required, other than, convertible interests. And it was that it used, with a number of different parties. It started with Microsoft, but it's now entered into these arrangements with a large number of other parties in order to get the funding, the compute, the capabilities that it required. But, that's not to say that regulators don't need to look at these transactions and see what the conditions are. Is there the possibility for exit? Will OpenAI go on to become an independent company? And I think most people think, to me, it's very clear that it will. So all of that sort of debate discussion is very important, but it does need to be done, I think, in a very nuanced way and as a discussion. And you're much more likely to get industry participants, startups, other to talk to you as a regulator if you conduct that discussion as a constructive discussion, rather than coming in, imposing interim enforcement orders, throwing the book at the companies. At that point, it becomes a very, it's an enforcement activity, and lawyers come to the fore. And I'm not always sure that we're the right people to have at the front of these sort of the debates, to be honest.
Thank you very much. Emily and Anush, please feel free to reflect upon this second sub-question as well.
Yeah. Yeah, I was just going to pick up on the point about, because that's very much what I took away from, certainly from Dr. Croxton's remarks, very much the tone of that, and as we've heard from the CMA more generally, and in their strategy, and in all speeches, to be honest, is this shift from more of a kind of a stick approach to this carrot idea of really focusing on encouraging and liaising proactively with businesses to collaborate, to understand, to work with businesses to kind of essentially generate, investment and make that a positive climate for the UK. And that's very much, it's certainly the helped by the groundwork, as you said, Jenine, about the groundwork of their understanding of this industry. But I think we should also probably recognize that is very much being shaped by the tone and the tonal shift and the political climate that the CMA found itself in as well, which very much encouraged this shift in tone towards less focus on the kind of enforcement approach and more on enabling growth, innovation, encouraging investment into the UK in order to support the interests of the UK. And that's something that I thought was perhaps the slightly different tonal shift you could hear between actually the remarks from Karen and the remarks from Bryce Elibert, who was probably, I'd say, a little bit more focused on, we're watching this market, we're waiting to see, things aren't that different necessarily. Some of the problems may well emerge that we've seen happening before, so we're watching, and in some cases they're already taking action, which is in a little bit of a different place, I think, to where the CMA are, which is a bit more, and as we've heard, much less pro essentially regulation and intervening early on, and much more, holding back, engaging, liaising with businesses to understand the kind of landscape as the starting point. So I think that's a shift really, and a difference. And that was quite evident from the two sets of remarks that we heard.
Thank you very much, Emily. Anush?
I also found particularly informative what Karen had shared in her keynote about the data technology and insight unit developing hands-on understanding of firm strategies and business models in AI when she was discussing the four strategic goals being championing consumer interests, tailoring PCIs, instilling confidence, and leveraging UK design to prioritize UK interests. So I think, as Emily also pointed out, the conversations that are had in the UK have slightly shifted to this growth agenda, perhaps, which is also quite well reflected in the 2026 to 29 strategy. Coming to a point regarding, let's say, enforcement or taking action against any sort of infringements, the UK is also in this unique position where it has several tools in its hands. It has, first of all, the market investigations tool. Jenine had mentioned the foundation model market study. So I think that's a great starter. The market investigation tool also allows the UK to go into in depth into any particular market, any emerging market also relating to AI, perhaps even agentic AI. And then further on, they may or may not take any action. So I think that tool is quite essential, and it'll be quite interesting to see how the UK uses the market investigation tool. The second tool is CA98, where if there is an infringement that is proven, then the CMA may take action. The third and final tool is perhaps the most interesting one, at least from an academic and a practitioner point of view, which is the DMCCA, to see how the DMCCA comes into action and what it does with these emerging AI markets. So this toolkit approach seems well suited to AI markets where competitive dynamics don't fit neatly into one single regulatory category. One observation from the academic literature also resonates here, that the CMA's emphasis on online choice architecture and algorithmic collusion reflects growing scholarly attention to how AI systems can affect competition through mechanisms that traditional antitrust perhaps may not be able to anticipate. As well as this idea that the data technology and insight unit is developing hands-on unit, hands-on understanding of AI business models, which is perhaps the way forward to assess how AI markets are emerging. Because right now, I think we've seen generative AI in full force, but we are yet to see how agentic AI and robots, which also was mentioned in the conference, would emerge in the coming years. So it's quite clear to see that the CMA's messages, they don't want rigorous, heavy-handed enforcement right now. What they would seek to do is engage with academic research, but also international networks with the firms themselves, and act further on.
Yeah, I was just going to add, because I've led a number of market investigations back when I was a director at the CMA, and I mean it's a great tool. And the markets regime is as you say, it allows a comprehensive view of a market without apportioning blame or in the context of that kind of enforcement context that you get with the CA98 case. But I would say that they're big, weighty, it's quite a heavy tool to use, and comes with really high expectations, often about what may or may not come out of it. And so I'd say the CMA might be somewhat reticent about using that tool, particularly in this kind of rapidly evolving market, because it's not as flexible and light of touch, if you like, as something like potentially the new DMCC powers could be. Although in reality, even those powers, I think, are proving more. Certainly, they're still essentially being set up, and the kind of groundwork is still being laid, because they're still going through the process of designating and setting in place initial codes of conduct. So I feel that is also, like, they've got some groundwork to do first there before they think about using any of those tools. I actually think the consumer powers might be quite an interesting space, because They have new very weighty powers there. And it's possible that we might see them thinking about whether there's, as to go to kind of Janine's point about AI washing or other concerns around how AI is being presented to consumers. That might be an interesting space to see if they use their powers.
I think one
Yeah,
addition also here on the DMCCA is that the sheer amount of flexibility that the DMCCA affords the CMA, I think that's also something that they would take into consideration, because the CMA is perhaps the only competition authority to have even designated or included any sort of AI service within their digital market regime, which the EU is unable to do currently because the DMA is quite rigid in comparison. So I think there's definitely a benefit for the CMA in terms of taking action as it suits. However, there are these time constraints issues which the DMCC also has. It takes a long time for anything to actually happen. So I guess, yeah, there's both pluses and minuses there.
Yeah, I think one of the things that's really important to sort of understand, particularly given the sort of the growth agenda, is obviously the investments that we're seeing in things like compute. And these are, I mean, I think it's, it's now sort of well understood that these are multi-billion-dollar investments, tens of billions dollars investments, that for example, the amount of data center construction in the US is projected to outstrip the amount of, office construction in the years ahead. So this is huge amounts of investment. There is very much a global race on to attract that investment at the moment. In particular, given the way that the Middle East and a number of different countries in Asia have been looking to sort of really present themselves as global hubs for these data centers going forward. And one of the things that's really important to understand, and that I've seen in industry after industry, is when the CMA opens a market study, most companies will think about pausing their investment plans until they get more clarity around the likely outcome of the CMA market study, because the outcomes have such a broad potential sort of range. They can be almost anything. And if you're unsure if the CMA is going to go for something, to take a very broad example, something like either a requirement on the one hand to give notice to consumers, or anything up to price control, that's an incredibly difficult thing to try and sort of manage as a company. So one of the things that the government, I think, is trying to sort of, and the CMA as well, is to make sure that we have some sort of sense of where the CMA may intervene, without fettering the CMA's discretion, but to try and to provide a little bit more sort of certainty as to the areas where the CMA is likely to intervene, is likely to take action, but in a way that doesn't deter investment in the UK at present. And that again is a real balancing act, because you do need to obviously maintain consumer confidence in markets. That's incredibly important. I think everyone understands that maintaining consumer confidence in relation to a technology like AI is incredibly important as well. Markets need to function. So the CMA needs to be ready and willing to use its toolkit, but not in a way that is, that is so out of line with other jurisdictions, or out of line with the public debate, that it's sort of seen as something that really deters or chills investment. And that's an incredibly difficult balancing line that I know that Sarah and Karen and others are trying to tread at the moment.
Yeah, I completely agree to that. Just jump in, just because it prompted a thought about, I think the risk is always, it becomes, when thinking about the use of competition powers, it becomes this idea that it's always a negative effect on, and I think you're right, Jenine. I think in some contexts it really can be it can have a freezing effect, and or it can have difficult consequences for businesses. But then I think, and Karen very much emphasized this in her remarks as well, there are areas where, and we're seeing this around in Europe as well, where actually competition can be used as a tool to unlock services and competitors and interaction primarily through things like enabling interoperability, and ensuring access to devices, for example, is one of the things I know you also emphasize very much will be critical, because so that a range of businesses can access consumers, and that's really an enabling measure, and that's very pro growth, that's very pro business actually.
Yeah, and I think there's going to be some really, and Anush, you sort of mentioned IP, and I think IP is a sort of a really interesting area, both in terms of access to IP in order to to train the models and to bring them to market. But there's also this sort of secondary issue now. We're seeing this in cases like there's an Amazon case against Perplexity, which is not a competition case. It's an IP case. It's a case in relation to, I think it's brought under the computer misuse legislation in the US. But there, Amazon is basically sort of saying that if a consumer allows Perplexity to access the consumer's Amazon Prime account, so the consumer types in their own sort of login, that is still a misuse of the Amazon platform, because the Amazon platform was not designed to allow agentic AI services such as the one that Perplexity offers. It's a shopping service. And so Amazon is trying to take action based on its own IP to try and prevent that sort of happening. And these sort of cases, I have no idea whether the CMA will intervene or not, but these are just incredibly sort of interesting cases, I think, for regulators to keep an eye on as well. Because when you have that sort of interplay between IP rights, investments that companies have made in developing their own platforms, but on the other hand, the investment that's been made in sort of new technologies, such as some of the agentic, for example, shopping services, what trumps what? How do we sort of, again, end up in a sort of a situation where markets can function and we continue to have the right incentives for innovation? So again, whether that will be something that will be addressed under the DMCC, or whether that would be something that would be, you can also see this, the CMA has a track record of bringing cases and then quickly sort of settling them under the Competition Act, and seeking sort of undertakings or commitments. So there's a variety of different ways that you can sort of try and intervene. So I think you're absolutely right to sort of emphasize the really broad sort of range of different tools that the CMA has.
I think one small point I wanted to add to that, Jenine, is the head of strategy of Lucio, Vineet Agarwal, in the conference, he noted one very interesting point which stuck with me, which is smaller AI firms who want to compete with the current larger ones who dominate the market. They need the data to actually come into a position of significance to be able to train their AI models. Now, if we start saying, okay, you use data in certain ways going forward, however, the existing the Gen AI models, at least, have already done that. They've scraped the data and they have established themselves. So the smaller firms will never be in a position to be able to compete with them. So there are these two conflicting interests in a way, because one says implement data protection laws, and the other says, oh, actually, you need data freely for these smaller firms so that they could come into a position of significance. So it's quite interesting, as you mentioned.
Yeah, look, I think the other thing that's sort of really important to sort of just bear in mind is because these the generative AI, agentic AI, it's a technology rather than necessarily a use case. There is no way that, for example, a developer of models can fulfill every single sort of need. So what's been sort of really interesting, in the legal field, for example, we've seen companies like Harvey, which, provides sort of services that are tailored to the legal market. It now has sort of $1 billion sort of market valuation as well. So we there's just one use case. It's just a whole raft of different sort of companies out there now sort of providing targeted sort of services. Because you can't sort of satisfy every consumer need yourself. Do these model developers try and create platforms that are open to others or not? So again, I think we're just at the early stages of seeing how the sort of the models are going to develop and what that commercial model will sort of look like. So yes, but I think that's right. It's also always incredibly important for regulators to sort of sit there and think, okay, why are the incumbents asking me for a particular form of protection? That's always, I think, a question that a regulator would be wise to ask themselves.
Yeah, and I was just going to quickly pick up on, because one of the interesting things that I think may play out in the future is also the personalization of AI services and models. And that is an area where the regulators have already actually done some thinking about the use of access to personal data. And there's some potentially parallels with, and I might be stretching a little bit far here, but parallels with some of the work, because I also worked on the banking investigation, and that implemented obviously open banking, which was about access to people's data. But there is now this debate about how far that should go, and banks have obviously their own IP and their own relationships with consumers, and they also don't want to be kind of disintermediated. But potential parallels here in terms of, particularly when thinking about search, for example, and the amount of personal data that Google has amassed, for example, and in its potential advantages that it has in bringing services that can be tailored around that mass, data set, and the extent to which regulators start to think, well, are there some data sharing enabling provisions that would actually encourage and enable more services to offer personalized AI services to people. And I think we've seen some thought about that in the US on the remedies judgment there from search. So I think that's a really interesting area to watch out for.
So many interesting topics, particularly the latest ones you mentioned. I wanted to maybe to engage a little bit in a comparative exercise to look at two approaches, simplifying a bit UK and EU, where EU appears to lean towards kind of digital autonomy or sovereignty. The vocabulary is very proactive, and the idea underpinning it in a kind of stylized form is that we are in this kind of new industrial revolution where the access or having their own infrastructure is comparable to having transportation network in the past. And without having the infrastructure or the backbone, you doomed to somehow to relegate into a second tier economy or polity, with all the spillover effects on society, versus the approach which is kind of more realistic, which appears to be dominant or more prevalent in the UK, where there is room for everybody, just integrate with the existing kind of players. Maybe there will be newcomers who will challenge it, but the markets will somehow self-correct. There must be some targeted interventions where it's absolutely necessary, but overall, let us rely more on the invisible hand. And it's fine to be somehow a farm club of the existing giants, as long as the market is growing so quickly, and as long as you are meaningful players, you have an opportunity for growth as well. It's a caricature, I understand. And yet, I wanted to pick up your ideas. How do you position your understanding? Which approach is more suitable, which is more effective, which is more realistic, and which one you support? Jenine, let's start with you.
So I think what's again sort of really interesting in this area is that we are actually sort of seeing, particularly around the development of the data centers required for compute, which are basically data centers that have a lot of GPUs, TPUs, the sort of the silicon that's required to train and run the models. Because the demand is the scale of the demand is so huge, we're actually seeing a huge number of what are called neo clouds entering the market at the moment without any intervention. So we see sort of companies like CoreWeave. We see companies like Nscale is a really interesting company that again has come out of sort of Bitcoin mining, has an energy related sort of background, is sort of developing data centers both in Norway using renewable energy and also in the UK as well as in the US. And there just is there's a whole sort of long list of them, Lambda Labs, a variety of others. What's also sort of interesting is to see some of the people that are providing the backing for those companies, and that includes companies like Nvidia. So Nvidia is obviously very keen to sort of ensure that there is a large number of other alternative cloud providers, because that ensures demand for their own sort of chips, and they are using and investing capital in ensuring that those companies develop and emerge. And again, one of the companies that we spend a lot of time talking about at the moment is Oracle, given the scale of the investment that they are now making in this area as well. So I think it's just really important that the debate is grounded in the facts and what is actually happening in the industry. And the debate doesn't become a very sort of a stale debate that is just around regulatory sort of policy, because the size of the investments that are required means that this has to be driven by the market, unless we are going to sort of see governments themselves invest in data centers, which I suspect, given the constraints on the public purse that we face, in every country, isn't going to happen. So I sort of I find this debate, in particular, I understand the need for sovereignty, but then I think that discussion then means, okay, we need to start talking to the new entrants. We need to start understanding their perspectives. But again, we also need to bear in mind, one of the largest customers of CoreWeave, I think, is Microsoft. We are sort of seeing a very sort of significant sort of, again, commercial relationships building up between these new entrants and the neo clouds, which I think is super interesting as well. So I think I definitely prefer the UK approach of let's wait and see, let's see how the market develops. Let's make sure we sort of discuss this. I do understand the sovereignty sort of issue, but I do think that sort of sovereignty discussion then needs to be rooted in what's happening in the market in this particular case. It's a bit unusual.
Thank you very much, Jenine. Emily, you've been at the CMA at the time, at the peak of this enthusiasm about building up or helping UK industry to scale up and to take the central or important place in this hierarchy or in this kind of digital ecosystem, cosmos, universe. Your position on it, and how do you evaluate this transformation or metamorphosis which we observe in the UK regulatory and business environment, or this shift towards more kind of pro-market, pro-growth narrative?
Yeah, I mean, just to be, I mean, the aims and aspirations haven't changed at all from the CMA. I think some of the approaches and the emphasis, some of the trade-offs have probably shifted a bit. But I do genuinely think that ultimately, the idea that the competition is pro-growth and pro-innovation and pro-investment is always been it's always been a kind of fundamental mantle I don't think anyone would argue with. And I think the CMA And just to pick up Janine's remarks, the CMA is not in a place to kind of pick winners and losers. It doesn't like to do that. It doesn't want to do that. It doesn't want to favor one versus other. It just wants to create the conditions for positive entry, expansion, investment. And to the extent that entry and expansion investment needs to come and be centered around UK businesses, I genuinely think that's a policy question for the government. And if the government wants to achieve those aims, then in a way, it would be helpful for it to be clear about that and for it to do so explicitly. and then we're kind of all clear what the groundwork, the rules are. But I think otherwise, the CMA's, mantle is really to just create investment and innovation and the right conditions on a kind of neutral basis. And that's a kind of core tenet, really. And if there's a shift in that, then that really needs to be a policy question at the heart and to be directed by government, much like we used to have the kind of public interest, test where they there still are occasions where they can directly intervene because there's a policy goal that's prioritized, and that's fine. And if that's the case, that needs to then it would be better to be explicit about that. Otherwise, I think we're really where Janine said, which is we're encouraging investment and we're making the conditions suitable so that everyone can prosper, rather than necessarily saying it has to be one company versus another, or the conditions around which company it needs to be, UK-based company versus others. So I think that's probably where we are. And I think I don't think this UK has ever really been very comfortable conceptually with this idea of a national kind of champion. It's just not really in the mindset of the UK, and I think that's just a bit of a central difference that's always been there between Europe and UK, and I can't really see that changing significantly. But
thank you very much, Emily. Anush?
So I think both models, the DMA, DMCCA, have their strengths. The DMA offers some amount of legal certainty. Gatekeepers know their obligations from day one, and also, one thing that's quite interesting to see is between November and December, the Commission has opened 5 investigations on different AI services, on AI, the cloud infrastructures, also on Meta AI, and on Google AI. So you can see a lot of action being undertaken in Europe. On the UK side, the DMCCA's activity-specific designations allow more nuanced treatment. As we saw in the Google search designation, the CMA is the only authority to include any sort of AI service within the scope of a digital market designation, which is AI overviews was included within the scope of the designation. However, they excluded Gemini for certain reasons. That kind of granular distinction would be harder under the DMA structure. Currently, the CMA's roadmap methodology also enables phased interventions that can adapt as markets evolve. So the CMA consistently considers the decisions that it does undertake, and it has the ability to change them as it continues to as the market continues to evolve, as well as the CMA's DMCCA regime continues to evolve. So I agree with Jenine on that point. There are concerns as well with both, though. The DMA's rigidity may struggle with AI services, as we've seen currently, because the DMA has required a full-fledged change in order to incorporate AI services within the scope of their Article 3 designation. So this is quite clearly a problem within the DMA, which may change when we see the new law in April or May. For the UK, the bespoke system demands tremendous amount of regulatory resources, and the CMA, I've often heard in several conferences I've attended in the last 3 months that there are a lot of capacity constraints. That is why they take a long time to decide on the several aspects that they do decide on. 9 months for a designation, many may consider that to be a very long time. However, on the flip side, the CMA does extremely thorough investigation, provides a lot of evidence of why it does and what it does. So there is that amount of thoroughness, but at the same time, they're not able to take on many tasks together because of capacity constraints. So we've only seen 3 designations. So the question arises, will we see action against generative AI and other related activities anytime soon? So that question does come into mind. So my view is also that it's quite early to declare either the EU method or the UK method as superior, as one model being superior to the other. So I think it is something that we can consider as we move forward.
Can I ask you, please, recommendations for students? Emily.
Yeah, thank you for this great talk. And sorry, I have to leave a bit early. Recommendations for students. Well, I mean, I'd obviously recommend reading, if you haven't yet, like reading all the amazing reports that regulators have produced around AI, just to get really in the heart of understanding the technology. And then I dig around for some technical papers to, again, see what technologists are talking about, because I think they're a bit ahead of the game sometimes, and then you can really spot some interesting issues and trends that are coming out if you go and look at some of the actual kind of more technology focused papers that are being written right now. So that's my tip for students.
Jenine, your recommendation?
My recommendation is to really watch some of the developments that are coming out of Silicon Valley. So every year, most of the companies will have a big showcase where they show all of the different technologies that are coming in the year ahead. So all of the big technology companies do this. So Apple does it, Microsoft does it, OpenAI does it, NVIDIA does it. And these showcases, I think, are a sort of a wonderful way of hearing from the companies as to what they expect to sort of see in the year ahead. And I think that gives you then and often they'll actually bring people on board to demonstrate what their different sort of services or products are able to do. So I think that's sort of super important. And then the next thing is obviously what's really fun is I think trying some of these things and just using the technology yourself and seeing what it can and can't do. I think what we all find in business is that there's a huge number of promises made about the technology, but its ability to actually carry out some of these different activities is much more sort of limited. So one of the things I'm always very keen on is just hands-on sort of trying and sort of seeing. I think that sort of really helps. And then there are some great information sources. The information itself is a great sort of newsletter. They do a newsletter. They have a paid for subscription news service as well. But there are lots of free newsletters that come out of the information that I think sort of really tell you what's going on. There's some really interesting academics that I think are sort of really publishing a lot. One of my friends from university is Joshua Gans. He's just about to publish, I think, a book on the microeconomics of AI. So this is one of those areas. I think it's limitless. There's so much you can do. So there's just try a number of different things and find what interests you.
Anush?
I think for students, they're in a really unique position, because one thing this summit reinforced is that nobody has all the answers. People who have expertise in different fields have to come together and try to find the answers, as we have also reflected in today's conversation. So practitioners acknowledge that they're navigating these evolving frameworks, as would also students when they do study AI, as well as the role of competition law within AI markets. So also, AI regulation isn't just an EU versus UK versus US versus China versus Asia sort of debate. I think it's important to understand the different approaches and try to compare which works effectively, what are the limitations, and try to see the differences. And this would be quite valuable not just for the students, but also in terms of them trying to bring all this knowledge into practice in the future, whether they become lawyers, whether they become academics. I think it'll be quite interesting for them to assess different approaches when it comes to AI regulation. Also to students, as Jenine mentioned, and also as Emily mentioned, there are loads of resources right now on AI. I'm currently reading a short book called The Shortest History of AI, just to try to understand the technicals of how AI markets work from a more technological point of view. And I think if students are from a legal background, it'd be quite beneficial for them to delve into these different fields as well, just to make sure that they understand the nitty-gritties better. But also there are loads of resources. I would also like to flag SKIDA has its own resources in the form of blogs, in the form of papers. Also, we run a podcast as well where we discuss different issues relating to AI. So that's also something that may be interesting to students. Also, one small aspect that I'd like to mention for students is going through the European Commission's website, also the CMA's website. They keep updating whatever happens on a daily basis. And it would be quite useful to check what's happening, new cases or new developments, because there are loads of things that are happening on a daily or a weekly basis. And it would be, I think LinkedIn is also quite a useful platform to make sure that they don't miss anything.
Jenine Hulsmann, Emily Chissell, Anush Ganesh, thank you very much for sharing your ideas with us.